Good morning, friends. Namaskar. In continuation to my earlier video, this is my 293rd video. Now, this is regarding Secunderabad. Now, this is a very peculiar kind of a cantonment because it fell under the foreign ministry during the British era, and the CLA rules for Secunderabad and Aurangabad were notified in a separate foreign department notification of the British. So, what is the difference in these cantonments and how these cantonments work, these two? Now, we'll come back to the same story. Here, the Hyderabad Metropolitan Development Authority, for constructing the elevated corridor of the state highway, they want to resume some or they want lands from the Ministry of Defense. So, this letter goes from the Ministry, the Government of India, on 1st March 2024, and it speaks of that since there is approximately this HIMDA is going to be requiring some land, so a cash compensation basis on 503,408 square meters for the elevated corridor and tunnels at certain places is to be made. And this letter varies, starts from 2016 policy letters of 2020. So this construction finally means that there's going to be a transfer of approximately 45,000, 4,59,222 square meters. So an equal amount of compensation has to be paid. So that this letter runs into some 9 pages of the ministry. I just mentioned you the date. Now I'm not going to be concerned much on the A1 or AA1 or A2. I'm more concerned on B lands. Now there is survey numbers. The government is saying what is the GLR numbers. So it says a bungalow having survey number 280 with an area of approximately what does it speak? About 53 acres. So what is the value they've on the circle rate calculated approximately is some 12, I think, lakhs. Okay. So when you go in for the STR rate, it grows a little bigger. Similarly, old grants survey numbers 105, 106, 111, 112, 140, 144, 288, 289, 465, survey number 704, 691, 477, 153, 154, 155, and 103. Similarly, survey number 464 and 77. This B3 land is also going, this is now in the management of the DO. So there are leasehold bungalows, that's survey number 78, 285 oblique 2, 478, 693, and 703. The valuation which is being calculated runs down to approximately 22 crores 11 lakh some 21,768. Another list of old grand bungalows which varies to a huge number from 30, 150, 30, 150, 30, 1507, so 30, 1550. Similarly, this keeps going on, and 457-113, 457-114, 279-1, 279-91. These are all in the management of the cantonment board. So the valuation here also touches to approximately 11 crore. There is a lease part of the bungalow also. B4 land is also going CB2. So this is now for the construction of the elevated corridor. Now this valuation works out to approximately 94 crores. 95 crores, 44 lakhs, about 11,234. No, 1 lakh 12,234. So another transfer they say is going to happen, which is again being valued at some 74 crores. Yes, 74 crores a cash compensation. Old Grant bungalows again here are going survey number 548, 588, 513 and so on. So this valuation is being proposed. Now, friends, we need to understand. Now, there is some land which is going outside Can, that is Hakimpet. This is AA1 land of the IFA. So, Indian Air Force, I would believe. So, these lands are being transferred and a revised EVI cash compensation on the basis of the MOD is being worked out. So, who pays this money? It's the state government or the railways or the corridor highway people. It's all a matter of between the government. But does the bungalow owner or the resident of this bungalow B3 land gets? See, we need to understand why is the government not willing to pay us. So in the last corridor, it is insofar as defense land held by holder of occupancies on old grant terms is concerned, the working permission is subject to the decision of the competent authority on resumption of defense lands required. So he gives a detail. The area is approximately 56,385 square meters. Similarly, which is in the Cant board area. We need to understand what are we actually all bungalow owners harping on. So now finally they say, let's resume this land. There's going to be a partial resumption. That means Supreme Court's order that no partially grant can be resumed are of no bias. I just gave you in my earlier videos that in Meerut they resumed and they finally even taken away that money. So Hyderabad Metropolitan Development Authority is finally paying out this. But is it actually being transferred to the bungalow owner? See, you have to understand the bungalow owner is fighting on various rules. This entire letter, nowhere it speaks of bank account numbers, everything has been given. Government is saying it shall deposit the requestee public funds through the DO securities. It's all a fiasco. We guys don't even understand that what is this. Lands are being transferred, resumptions are being done partially. We are not being compensated. Why? Somebody approached me, there was some bungalow owner, and I very clearly, I remember I told him somewhere on, I think in January 2026, that we need to dig into the very fact that we old grant bungalows, Secunderabad people have a story to narrate that we are a part of the Nizam terrain, because even Aurangabad was a part of. Partial Aurangabad falls in a Nizam state and the upper Aurangabad does not fall in that. So I asked this bungalow owner, please dig into your sale deeds. You'll have to fight for your GLR that this is a fraud document prepared for the first time in 1925. What was prior to 1925 were we called revenue-free grants. Second, are we willing to relinquish our rights in the soil for the widening of the road or these developments? This is a public purpose. Where is it written in the Quartermaster General Circular that reacquisition of government by government of sites granted with any building erected on such sites, the commander-in-chief is advised that building erected with the permission of the government on government land can be compulsorily acquired under the Land Acquisition Act in taking action. Cantonment committee must be able to prove building concerned that the land is the property of the government. Guys, this is being written by a commander-in-chief in 1905. But yet, Secunderabad people, I know, I'm not saying they are wrong. We don't need to go into whether Nizam or whether Holkar estate. We just need to go straight with the laws. The Britishers very honestly, why they wrote us old grant? They could have just written us grant under GGO 179 when the GLR was first being prepared in 1925. They didn't. Why? Because they knew all along and they were waiting that let's see, will anybody in India after 60, 30, 20, 50 years will define this terminology called old grant? Or would he read these books written for the regulations made from 1767? So here this order says the declaration under section 6 of the act should state the land is needed for public purpose and not the house only. So friends, here it is a clear case. It is being used for public purpose. It is to be remembered that the cantonment committee are under an obligation to pay compensation to the owner in respect of his interest in the land, including the value of the building. Please, yaar, wake up. I'm requesting you people, wake up. I know most of you people don't want to watch my videos. Most of you feel very burdened. The commander-in-chief has been advised that this interest in the land represents the right to enjoy the site in question until it is put an end to by 1 month notice in accordance with the cantonment regulation. It is to be noted that the words value of building do not mean the value of the material. Everything is so clearly written. Who's going to read them? So I asked this bungalow owner, I remember. He's not called me back since then. Collect everybody. There are about more than about 70, 80 people from there are about 40 in the bungalow area and there are about 80 people in the civil area. Collect them, bring them under one umbrella of the acquisition of the National Highway Development. Let's say this is a small association and I'll fight their case. One issue that we are owners of our old grant. Second, we will plead that the GLR is fraud. Third, we need to be compensated. Fourth, how the same compensation has to flow in. Till then, do we ask for a status quo with the old grant or do we file a suit for injunction? After all this is accepted by people in those cantonments in Secunderabad, whether in Meerut or in Mau cantonment, which I have in hand, then I will go in for those Janampatris, will ask for your property documents because every fact changes with the documents. Your GLRs, your sale deeds, your 12 years receipts of house tax, any court case or departmental litigation which has happened in the past 70, 80 years, any language document which is in Urdu or Hindi would need to be converted in English. Any evidence which I will dig into from documents of yours, any historical evidence of Secunderabad or Meerut or Mau, all this needs to be. Then I very clearly said that I'm going to charge, there's going to be nothing free. Most of the people want to file writs. Please, friends, understand. In a writ, you cannot declare your ownership rights. You need to go through the lower court. In a writ, you can all say this notice or this resumption which is being happening is illegal. How? These are the facts. But because we need to fight ownership, we need the case to be remanded back to the lower court. So this is how we will lead evidence. Okay, maybe the government might say that we can't delay the project, so they may go under section 16 of the Land Acquisition Act, which is called emergency or compensation compulsory acquisition. Fine, let them go ahead. We will say we are ready to part with the property. But we need an undertaking that our compensation has to be paid and it is not. This Harish Anand judgment does not bind the court with the notice. Purposely, the government writes it and it says, okay, fine, we're going to hang you out. So, friends, wake up. It's not a very big thing. We can all fight it out if we want. And apart from the writ, facts have to be narrated. Court must try and understand what the facts are, because in the last 98 years, there is not a single judgment which we won. Have Secunderabad people won any single judgment under the Nizam by declaring an history? Let's go outside the Secunderabad cantonment. Has anybody in Mau, Aurangabad, or Secunderabad won any judgment? Minus the cantonment boundary pillars. I have judgment against in Aurangabad, Secunderabad, and of Holkar state in Mau, where a grantee outside the cantonment went in that we were in Schedule B land, this Holkar never accepted, and Secunderabad was an independent state. So what? So please, let's not, just live in that fancy. Now, I'm very, the department just shared a document with me, and there was some kind of a writ filed by some these bungalow owners, and the honorable court in that writ on 7th April 2025 had pronounced an order. Though that various grounds are raised in the writ petition, the learned counsel, respondent number 7, Secunderabad cantonments, and so vary and all, they had put in a representation. Now, what does that representation say? So, the DO and CO have been bounded that you dispose of that representation. See, you need to understand these representations are all half-cocked. You start fighting from B3 land, you start fighting from GLR. So basically, you don't know what we have to fight on. Basically, the fight has to begin from 1836, September, when the GGO was influxed on us. So either you go prior to it, because if 1836 GGO has been influxed to you, so you must have been a grant during that period. So Secunderabad boundary pillars need to be known, Mau boundary pillars need to be known. Similarly, Meerut. Once these boundary pillars are defined, let's say Meerut was made in 1890. When was Secunderabad made? When did Secunderabad settlements happen? So from whom did the British acquire the lands? You'll be surprised, the first TP Act came when? Not 1882. It way back came in 1822. I have the original TP Act 1822 with me. So sales were being considered under that. So that means prior to 1836, my bungalow was being sold, or my property or my grant was being sold. Where is it written that these old grants were revenue free grants? Okay, ask yourself. All B3 landholders who are old grant, whether in civil area, whether in bungalow area, are you guys paying any lagan, anything other than house tax to the government? No. The government after 1889 started taking these very B3 lands or these old grants converted them into leases. So lease, a lessee is paying some rent or lease money. There is also a different story. Ask a question to yourself again. What is our lease and what is a lease which you may make of a property to a tenant of yours? Tell me one thing, when you make a lease to your tenant, does he have the right to sell that lease? Does he have the right to repair that lease or construct that lease? Friends, understand, even if the government says that they granted us land, they granted us barren land. So they are the owner of the land and we are the owner of the building. Even in the lease case, they have not given us a lease of a built up estate. They've given us a lease of a land. So that land again is built up by us. So we are two owners. They are the owners of the land and we are the owners of the built up state. So when there are two owners, how can one owner decide about my resumption or my PP Act influxion? No, he cannot. The law is very clear. He has to give me an opportunity. So, these representations go varied. So what is this representation which the CO shared with me? He says the representation, it is so funny. You are once again saying we are asking them to convert our B3 to B2 land. How will the ministry do that and why will the ministry do that? Where is B3 defined? GLR has been upheld, GGO has been upheld. What are we fighting? GGO 700 of 1852 Has anybody read that GGO? Where is that GGO? You'll be surprised. All GGOs, whether 1838, 1828, 1836, 1855, any of these GGOs. So whether Madras presidency had the Bengal GGOs applicable, yes. Punjab, Bombay, all Governor General orders passed by the Bengal presidencies after the 1861 Indian Council Act became applicable on these three presidencies along with Punjab. You know, I have a case in Ambala where the DO is saying that Bengal presidency was never applicable on Ambala cantonment. Just imagine these officers sitting there or these UDC clerks, they don't know anything. Guys, this is a classic case. Just look at the amount, public purpose. This entire money should be transferred to you people, which the Department, Ministry of Defense is asking the HMDA for this highway. So all I can say is you people need to wake up. You people need to get together. B3 people, whether they are entitled to compensation, he says they are, provided if there is a structure standing there. If there is no structure, so he says for land we will not give you that. Regarding leases, he is very clearly saying if the leases are expired, your right to compensation also goes. So this reply itself is so dangerous by the department. Now, regarding regulations or acquisition, you know, somebody approached me, he says, Mr. Das, we've got 4 cases where it has been given by the Ministry of Defense that these bungalows are freehold bungalows. Fine. Can't the government acquire freehold bungalows? It can, yeah. So we are not getting into it. All we are looking for is the rightest compensation under the acquisition. So we need to understand what is the difference between acquisition and resumption. See, GGO has been upheld, GLR has been upheld. So what are we fighting? Now, this representation, I was surprised, you know, it was saying that you change the alignment of the road. How can that be done? That's a master plan. So these are various writs filed by some writ number 10422 of 2025. You know, again he says my father was inherited, property has been flowing down since I don't know which period. You people just forget there is an admission. Everybody after 1925 has given an admission. So that admission needs to be challenged. Where is it written in rules, CLA, that you have to give an admission? No government department works on its whims and fancies. You can't just randomly pass an executive order and say, okay, Mr. A, from tomorrow you will give an admission deed. So these are so many questions which need to be understood. And then we can really make effective our representation, our cases. There is, I was told that even Secunderabad Club, a prime property, is going under this. So let's wake up and we can all fight it together, provided we come together. Thank you. Good day.